Hello. Welcome to a podcast on the law and its impact on computing technology and business. This is Brian Gaff. I'm a senior member of the IEEE and partner at the Edwards Wildman Palmer law firm in Boston. The IEEE is presenting this podcast in conjunction with my column that appears each month in Computer Magazine, a publication of the IEEE's Computer Society. That column discusses legal issues relevant to people in the computer hardware, software, networking, and service businesses. In the last podcast, I discussed the first sale doctrine. In this podcast, I'll discuss patent enforcement by non-practicing entities, also known as NPEs or patent trolls. I covered this topic in my July 2013 column in Computer Magazine. First, let's define what's meant by an NPE. Traditionally, NPEs are those companies that own patents but don't make, sell, offer to sell, use, or import any of the products or services that those patents cover. In other words, the NPEs do not exploit their patents in the traditional sense. Sometimes an NPE results when a company that was engaged in the manufacturing and selling of a patented product stops doing so and instead just relies on its patents. That is, it simply looks to sell licenses for its patents, rather than manufacture or sell products that those patents cover. More often, however, is that companies are specifically established to acquire patents that aren't getting much used and then look for ways to derive revenue from them, most often by suing people or companies that are believed to be infringing those patents or by agreeing to license those patents to people in return for a royalty payment that's either provided as a lump sum or provided over time. The reactions that NPEs generate in the United States is usually quite negative. That may be because the perception is that they are trying to derive the benefit of patents that they themselves did not earn. Notwithstanding that, the NPE's activities do not flout, for the most part, any form of the current law. Indeed, there's a strong argument that NPEs are responsible for creating a secondary market in patents that aren't getting much use. That market allows original patent owners to dispose of their patents or get revenue from them, even though they haven't been able to do so using some of the conventional ways. A contributing factor to the negative perception regarding NPEs is that in many instances, their arguments of infringement do strain credulity. This shows up often when very old patents, sometimes ones that are approaching their expiration date or have recently expired, are being used to pressure others to take a license based on a theory of patent infringement that doesn't quite sound solid. An example of this is old patents that cover certain telephony technology. Some of those patents predate the Internet by decades, but still are being used today to enforce their technology limitations on Internet companies. That usually means an interpretation of the claims in the patent that is somewhat stretched and unconvincing to many folks who work for the accused infringers, particularly the patent attorneys who are charged with evaluating allegations of infringement and advising their clients, the accused infringers, for example, of the strength of those arguments. Because there has been a crush of these lawsuits by non-practicing entities over the last couple of years, there's been an increasing tide of negative reactions to them. This has culminated recently in the U.S. Congress attempting to pass some bills that they believe will limit the ability of non-practicing entities to sue, as well as some executive orders issued by the President recently that also have as their aim limiting NPE litigation. However, at this point, it's unclear whether any of those efforts will have any effect. So at this point, it's a fact of life that in the U.S., you need to be prepared to confront litigation brought by a patent troll or an NPE with an allegation that you might be infringing some patent that perhaps you never heard of, or at first blush you would think does not even cover anything that you're doing or selling. The first step you need to take is to consider the costs of dealing with any litigation that you may face involving an NPE. Patent litigation in the United States is exceptionally expensive. It's not uncommon to be in the $3 million range before getting to trial. Because of the expense of litigation, many NPEs have as their business model a mechanism by which accused infringers can settle early and for a cost that's less than what the expense would be to fully litigate the matter. Accordingly, it becomes a decision for the accused infringer and its executives whether they would like to spend more money to litigate or less money to settle. That decision has to be driven by, of course, the economics, the risk of litigation, the outcome of which is never certain, as well as the company's overall feelings about dealing with litigation that it is presented with. For example, many companies take a hardline view toward litigation and will not settle, and generally will litigate a case through and including trial as a disincentive to other potential plaintiffs who might approach it and also threaten lawsuits. On the other hand, some companies may simply want to minimize their costs early and quickly, and that means that they will likely try to settle early on before the legal fees and other associated costs start to mount. Whatever the company chooses to do, be it fight in a litigation or settle early on, it needs to commit to following through on the chosen alternative. For example, if the decision is made to settle, and that's not an uncommon decision, particularly when a startup is accused of infringement, because startups usually don't have much revenue to support litigation, but if the decision is made to settle, it's important that that settlement be kept confidential, because you would not want to create a perception that your company is quick to settle and might be perceived as an easy target for other NPEs or other plaintiffs looking to extract funds with minimal effort. But sometimes you just can't settle. Sometimes it's the choice, but often it's more likely because the parties cannot agree on a number to settle the matter. That can be more likely and more challenging if the NPE is well funded. For example, if the NPE has sued others and has accumulated a war chest of funds associated from prior settlements, it's more likely that it can go the distance on a litigation. If you find yourself in that situation and you are going to go through a litigation, you need to prepare yourself for the rigors of that route. The cost will be larger than settling, most likely, and the disruption will be palpable. That includes a lot of interactions between your technical staff and your lawyers, discovery, which would involve depositions of individuals with certain facts and knowledge of the matter, and document reviews and document collection, and review and collection of emails and other electronic items, which can be very burdensome for an accused infringer. But if there is a valid reason to proceed with the litigation, as I said earlier, you must be committed to follow through on it, to deal with it in the most efficient way possible, to minimize disruption and minimize the costs, which will be great to begin with. It's also very important to realize that the litigation outcome cannot be guaranteed. It's very unpredictable. What could happen at a district court level in litigation could be reversed, overturned at a higher court, and it's a process that can take several years to finish. A possibility is to proceed in the patent office and ask the patent office to review the patent or patents at issue. This is an alternative to litigation, And if you are successful in convincing the patent office to look at a patent, you may be able to put the litigation on hold, or to stay it, as it's known in legal terminology. Now, a review at the patent office using one of the review mechanisms known as an ex parte reexamination, inter partes review, post-grant review, or business method patent review can be very attractive because usually it's less expensive than a litigation, and as I said, if it's underway in the patent office, usually the litigation gets held up. You need to be careful, however, when you use these mechanisms because certain actions taken during those reviews can have limiting effects on a litigation that is temporarily on hold but will be restarted once the review is over. For example, certain positions taken during that administrative review in the patent office cannot be stepped away from in litigation. So if they are found to be ineffective in the patent office, you may find that they are also ineffective in the federal court, and therefore that would limit your ability further to defend against the patent. You also need to be aware of the fact that if the review comes out and confirms the validity of the patent, that makes the patent very difficult to invalidate later in a litigation. Lastly, with regard to the review in the patent office, sometimes it's tempting to join with others who have been accused of infringement and jointly pursue a review in the patent office. That can have a couple of pitfalls in it, including statements or actions taken by other members of the group that are pursuing this review might be attributed to all people in the group, meaning that statements made by one member could limit you as another member in what you can achieve in the litigation. Please consider that if you are going to fall into any type of joint procedure in the patent office or join a joint defense group, as I described in the column. Unfortunately, it's the cost of doing business in the U.S. that you'll need to confront some type of patent infringement or infringement of intellectual property and allegations and litigations that flow from those events. There may be some changes in the law that limit what NPEs can do in their litigation, but those changes haven't been instituted yet. So at this point, you just simply need to be aware of the likelihood that you might get ensnared in this litigation and work closely with your lawyers to determine the best exit strategy, which might be an early settlement or it might be a full-blown litigation. I hope that you found this podcast helpful in understanding some issues about NPEs and their litigation. Stay tuned for my next installment in Computer Magazine. Until next time, this is Brian Gaff. Feel free to contact me via email at bgaff@edwardswildman.com. Thank you.